back. So it's my great pleasure to introduce to you our panelists, and well, I get going from left to right. So this is Kris Morrison. Kris is a partner at Parry Lawyers. I'm sure you all know this law firm in Christchurch. And Kris has been a strong supporter of various innovative initiatives, and in his spare time, if he has any, he is also involved in a variety of charities and focused on education in general. And then we have Phil Johnson. Phil is the CEO of OneLaw, and OneLaw is a Christchurch-based technology company. They are offering a very innovative, advanced law practice management solution called OneLaw. Phil is also a founder of a not just consultancy, really, a services company called CommArc. And many of you may know it because they've been providing services to law firms for probably, what, 20 years? 30 years. Yeah, Phil is a serial entrepreneur, and I'm sure he will be very happy to share some experiences with you. We have Stephen Moore, a partner also at Parry Lawyers, and Stephen has a very interesting, strong background in both in-house and on the law firm side in New Zealand, also in Japan, and the UK, and Australia. We have Jarrod Coburn. Jarrod is the CEO of Portia Law, and you may also know this firm as Ebborn Law, and I have a privilege of knowing Jarrod for a couple of years now, and he'll probably say it, but just in case, Portia is one of the largest legal aid, and maybe the largest legal aid provider in New Zealand, and they are providing a lot of legal aid and legal services to clients who actually need this access to justice issue to be resolved. And again, we'll ask Jarrod maybe to say a few words about that. Then we have Dave Pugh. You've just met Dave maybe 40 minutes ago. And then we have Andrew Scott. Andrew is Senior Associate at James & Wells. He is a registered New Zealand and Australian patent and trademark attorney and a council member of the New Zealand Institute of Patent Attorneys. I had to read it so I wouldn't get it wrong. And Andrew, how many degrees you have? One is a PhD in synthetic medicinal chemistry. It doesn't have anything to do with cannabis, just to make it very clear. And he has completed postdoctoral studies in material science. And as an IP lawyer, obviously, something that's very important to have a strong background. Anyway, thanks very much for being available. I know you're all very, very busy people, so it's really a privilege to have you here. And what I'd like to do is just start it and then leave it to everyone, because again, it's not a one way. What we'll do, we'll start with a question that was submitted to us in advance, and that's use of technology to improve access to justice and better quality of legal services to people who can't really afford it that much. And a question for me before I sit down: what are the barriers to profitable innovation in law firms, and how could the law firm overcome these barriers? Because I think ultimate innovation needs to be profitable, but how to make it work is a very different question. Anyway, that's what I'd like to start with. Who would like to maybe start discussing this question of using of technology for dealing with access to justice challenges?
Do you want me to
Sure.
kick that off? Okay. So we've been around for about 7 years now, and we have grown from a firm that had 3 people to now one that employs 13 lawyers, and we have branches Christchurch in the central city, down in Timaru and up in Blenheim, but we also deal with other areas of New Zealand using video technology. One of the barriers to access to justice in this country comes from the inability of law firms to be able to deliver a service profitably. We all have, even lawyers, sometimes will say that it's very difficult to be able to afford to go and see a lawyer. In fact, the new Chief Justice, Dame Helen McKelman, recently on her inauguration, criticised the profession for the cost that they impose upon people for representation in litigation matters. The underlying problem of this is the lack of innovation in law firms, and the solution is innovation. It's as simple as that. But it's not necessarily technology. So we were able to innovate to meet the needs of our clients without necessarily having to come up with any new technology or to adopt anything that wasn't already pre-existing. One of the things we did very early on is we formed relationships with women's refuges. Now, over the last 2 or 3 years, domestic violence has become a real talking point in this country, and the issues surrounding the sensitivity of each of those individual victims of domestic violence and their pathway to be able to become safe inevitably involves having to go and see a lawyer. So the use of technology to increase access to justice, or the use of innovation to increase access to justice, was not only about being able to provide an affordable service so that we could make money from legal aid, which is about 1/3 of what a private law firm would normally get from a client in terms of money, but also overcoming some of those personal challenges that people who have been in domestic violence relationships for maybe 20 years have, to make that step into the very unfamiliar, often clinical and quite unfriendly environment that law firms present. And I'm not saying that lawyers or law firms are unfriendly, I'm saying the environments they present can be unfriendly and a wee bit overwhelming, especially to someone who's not used to dealing with a lawyer. People look up to lawyers, people think lawyers are flash, well they are in many ways. They're above average humans in many ways, because they have to not only be have the intellectual capability to practice law, they also need to be professionally at a much greater level than the average human being. But the barrier that professionalism presents to someone who's in a vulnerable state is something that needed to be overcome, and this is what we used innovation and to some extent existing technology to do.
Thank you.
I could probably add something.
Sure. Yes, please.
There's a couple of interesting things with the technology industry and the legal industry. You have a structured, regulated industry working with an unstructured, unregulated industry. And there's always one of them's moving at a much greater pace because it's not so constrained, and it's not following any rules in many cases. And so often the problem with technology is the fact that it's moving very, very fast, and it's trying to add innovation to an industry which historically moves a little bit slower, quite a bit slower actually. And so the high pace of change versus low pace of change, that intersect is often the problem between the two industries. There is, however, an interesting project going on in the US with IBM laboratories. IBM are probably one of the companies that puts in the most R&D out of most of the big tech companies, believe it or not. They're a huge research organisation. And they've been running a number of studies lately using artificial intelligence to solve disputes. So this is where the system is capable of reading all of the law, all of the contract, all of the information that's ever been written, and then you can basically present a dispute and a counter argument from both parties. And it's nothing happening, it's all research at this stage. So you wouldn't rush out there and think this is going to take place. But it's a good example of, I guess, some of the things that are happening. But the problem will always be the intersect between the two.
And yes, I think what immediately came to mind with the point that you raised there is that in fact technology is encouraging of disruption, isn't it? Whereas when I came to technology as a lawyer, having been a lawyer, it was quite scary to hear people talking about disruption all the time, because in my previous life that isn't what we did.
Yeah, I think it is, and I think a lot of people there's a lot of talk from a fast-moving, unstructured industry trying to convince every other industry that it's going to disrupt them. And it doesn't always succeed in that goal. But often, these initial levels of disruption, even when they fail, are a harbinger of what's to come. So even if they do fail, they're generally that forecaster of what's going to happen eventually.
Sorry, just one other quick point following on from that. The one thing that I found was that because, as you said, lawyers need to be knowing of things, and it's quite difficult as a lawyer to be coming to something new which then you don't know and you don't understand. And I've sort of seen that in action in a particular role where I've seen people who, depending on their age, if they've not come from being digital natives, then to have to come into it as a senior level lawyer to something which is technology that might help them is actually a very big ask.
I'd say as well that, the age thing is certainly relevant, but actually most lawyers, even if they've grown up as users of technology, they tend to be not particularly sophisticated users of technology actually. They might have lots of it,
yes,
and they've found ways to make it work for them, but it's not usually their first love, and they're not experimental in the use of technology. I wouldn't say that. The sorts of things that attract you to law as a university degree and then as a career are quite different from the sorts of things that I think naturally interest people who end up in the tech space.
yeah.
So all that to say, I think a lot of lawyers, and I've been a lawyer for practicing law for 17 years, and I've been a partner at Parry for about 5 years. I've seen certainly graduates coming through, very intelligent people who not necessarily that great at using technology. So I think that's probably an impediment to innovation, is that in our field, with all due respect to the lawyers in the room, it's an area where we're probably not that strong naturally.
Do you have any advice on how that could change?
You mean for if you're a lawyer now who's not very good with technology, how can you improve, or do you mean how do we improve that for future generations?
Both are good points.
I think for future generations, one of the charities that I'm involved with is Digital Future Aotearoa, which runs, among other things, a few different programs. One called She Can Code. It runs the Code Club Aotearoa program, which is aimed at getting school kids aged 9 to 12 a taste of what understanding algorithms, understanding programming, understanding what that kind of set of skills looks like, and learning them in a fun and gamified sort of a way. I think introducing those skills, because I think the way that our education system, they're trying to improve certainly, but the way that our education system teaches digital technology at the moment is pretty weak, and most teachers don't know how to teach it, and they think that if you use a device then you're teaching somebody about digital technology. It's not the case at all. So actually I'd go back there and say that those sorts of opportunities to actually give young children the intuitive knowledge of what it means to develop and be innovative with digital technology, what that actually means, got to start at that early age.
I think key to is hearts and minds. So when you set out to write a full practice management system from the ground up, you deal with legacy views and you deal with future views. And so you begin to, work with your various constituents and people that your peers. And obviously you get half of them trying to drag you back and the other half trying to drag you forward. And so you have to develop a platform with the past and the future in mind. And often with a firm, bigger firms especially, they'll be split between You know, I mean, I know when I first put a computer into a firm here in Christchurch many years ago, and the partner said to me, if you put that on my desk, I'm going to throw it out the window. So it's a bit better now, but you do have this, but at the end of the day, you know, you've got a pace of younger generation who wants to accelerate, and you've got a, you know, slightly older generation who just wants to slow down and get off the bus at some stage. So, and again, it's like that intersect I was talking about before. You've got to build for both until you reach a new continuum.
I'll tackle the second question, which is around
about
maintaining
profitability
while implementing new technology. So as a specialist intellectual property firm, we sit slightly to the side of most full practice law firms in the sense that our service offering is much narrower. And one of those is around patents. Okay, so patented technology, and one of the fundamental requirements to get a patent is that you have to disclose what the piece of technology is that you're trying to patent. As a matter of course, therefore, there's this massive wealth of information out there which up until recently hasn't been very accessible. And as technology manages information better, the average desktop user is able to tap into a wealth of information like it's never been seen before. So you're seeing a lot of new analytical tools being developed, new service offerings as a result of those analytical tools. So I'm sort of taking a slightly more positive spin on the implementation of technology in my line of work. It's provided a range of new service offerings for competitor intelligence, for firms, patent landscaping and so forth, just data mining. So I see, even on that fundamental level, access to data, tools around searching, developing patterns out of big data sets as being certainly the way forward for the way a specialist intellectual property firm can slot into existing businesses. Rather than a handbrake at all, I see technology. And like we're fortunate in that we've got I'd say a medium-sized firm by New Zealand standards, and a relatively young and small partnership, such that the implementation of technology can occur really rapidly, and there's not a lot of entrenched bias against it.
It's interesting as well just to think about our moment in history, like where we're sitting right now in 2019, because Kris and I particularly, we often deal with charitable trusts, and sometimes you'll read charitable trust documents that were drafted in the 1970s, 1960s, you know, and someone sat there and typed them out, you know, and if they made a mistake, they either started again or they got white out, or, you know, it was like the pace of change. If you think back to 30 years ago and what we're doing now, I guess my point is a lot has changed. I started practicing in 2001 in Wellington with a national law firm, and I remember when the first partner came in and said, "Look at this, it's called a BlackBerry." And we were like, "What is a BlackBerry?" Which is funny now because nobody uses them anymore, right? We've all got iPhones, but the point is it was this way that they could now communicate. And it wasn't until the next day that we realized, oh, they can email us anytime. And then services, so I ended up doing a 3-page contract for them and sat there with them and just typed it out and then emailed it to them at the end of the meeting. You know, like 30 years ago, you just couldn't do that, have that quick turnaround. But what I wonder is, in the future, if the clients will be able to, you know, maybe using chatbots, maybe there will be certain fields that they fill in, it will auto-populate the document. I won't have to be involved at all, and it will just be, whoop, there's your terms and conditions. And that's where it gets exciting for me, because I tend to be on the positive side as well. Imagine the time that would be saved from me having to type in this stuff and to draw, you know, copy-paste clauses and then check things. I could actually be, as a lawyer, hopefully helping this other client who needs more help with the strategy and what structure should I use and the more interesting things to me, rather than, frankly, the admin of getting a document looking beautiful. So I think there's huge opportunity as well in our moment in time, which is important to remember.
Somebody mentioned disruption before, and I think, well, I mean, a lot of people have, a lot of sort of commentators have different views on disruption and what it is. I personally have the view that we haven't seen any disruption in law just yet with regards to technology. There's just a lot of hype and talk about it, usually from the technology sector, and that does cause a little bit of uncertainty or concern amongst lawyers, particularly senior partners or more traditional lawyers. But the disruption that we're going to see that will be forced by technology will happen at that governance level in law firms. Now, those who aren't lawyers or who don't work in law firms might not appreciate that a law firm in New Zealand must have a lawyer who works in the firm as the director, partner, and shareholders. So if you're not a lawyer who works in the firm, you cannot hold shares, nor can you be a director of the law firm, aside from some tax dodging stuff that's in the Lawyers and Conveyancers Act regarding spousal relationships. This puts a lot of pressure on law firms because they can't attract third-party investment in New Zealand. What we're seeing at the moment is we're seeing quite a few law firms that have been around since 1852 with 17 partner names in the title, who have senior people who want to get their investment out. They can't get their investment, I mean, they can't leave and leave their investment in. They have to stay working in the firm if they have a share, otherwise they have to give up their shares. So to get the share of their money that they have worked their guts out for their whole life, they have to find associates who want to bankroll their exit. And so these associates have to go off and basically mortgage everything up to the hilt to pay this money. And these people, and they're all in that millennial range, I think looking around at the moment and going, why should I pay money for this law firm that still uses dictation and still uses admin people to type stuff up? And that is where the disruption's going to come in, because as soon as the technology becomes accessible and cheap enough, you'll start to see the law firms who are technologically capable and those that fall right behind.
I've got an addendum to that, because so as I said, we sit slightly to the side of IP firms, and in about 2014 in Australia they changed the Patents Act, which meant that a patent attorney didn't have to be a person, it could be a corporation. And you might have heard of this, one particular big firm over there in Sydney, Spruce and Ferguson, then saw this as an opportunity to effectively become a corporate patent attorney. So then they publicly listed and attracted an enormous amount of capital. They then acquired firms up and down the eastern seaboard, over in Asia. Now they've come across to New Zealand with AJ Park, which is the biggest specialist IP firm in New Zealand. There are a couple of other players that then came along as well. So fast followers, they didn't quite get as much when they listed. Then one of those players, the third one, was bought out by the first one. So what you've seen then in Australia, and now in New Zealand and in Asia, is that it has been disrupted, but by changing the law rather than through some other sort of technological disruption. And what it's meant is that it's completely bifurcated the sector in our part of the world to ones that are, from where I sit, brutally conflicted amongst themselves, because they still retain all of their various subsidiary firms that have 100 and whatever years, however many partners, operating for potentially competitors in contentious situations. And then you've got other people who aren't as well capitalised, say my firm, and the existing firms, who are trying to find a niche in amongst all of that, and this is all happening in the last few years. And I think it was a reaction to exactly the issue that you've highlighted, Jarrod, and that is that the traditional model, in some people's eyes, was broken and had a finite lifetime, and they were going to see it in their lives, and they wanted out. They wanted to sail off into the sunset. And that's exactly what happened with the managing partner of Spruce & Ferguson. Good luck to him. But yeah.
I can pick up on a couple of things, a couple of points. First, the cost. Jarrod mentioned cost as being a barrier to the availability of legal services to people. So, disruptive technology can help to reduce the cost of practicing law. So my layman's view of law is it's a bookshelf full of books which contain statutes, and then you have decisions which form precedents. And based on that corpus of data, you practice your legal skills to deliver that service to the client. Advances in machine learning and AI in recent years, and the acceleration that we're going to see in that area in the very near future, machines are capable of processing massive amounts of information way faster than humans can. So if we can use machine learning to assist us in interpreting that corpus of information for a given case, then that can reduce the amount of work that you as a lawyer needs to perform in order to deliver the service to the client. So disruptive technology can help to reduce the cost of providing legal services to people, or enable you to service more people in a given period of time. And I'm not sure to what extent AI and machine learning are being used in the real world in law at the moment, but there are certainly people putting a lot of effort into developing these tools in this area.
Thanks, Dave. I think the question...
Just make a comment on that, if I may. A senior judge in Mumbai in India started developing algorithms to try to deal with decision-making in criminal cases, and in the end hit a brick wall. But my question is this: I transcend, so I started cutting my teeth in law in 1967, so I probably predate by a long way everybody in the group. I also am very involved in technology and still fly aircraft with the most sophisticated technology. But my fear is this: I see a move away from the client relationship, which I believe is extremely valuable. I'm interested in this team of experts in the changing psychology of the lawyer-client relationship. If we go back to my antiquity, and we dealt with the magistrates court, I was wielding the sword for my client worked with me, I'll use the word intimately, with a little I, and we were not bound by volumes of what I regard as lunatic legislation as to how we dealt with the court. So there's an entire impedimentia being developed within the court system, and then they blame the lawyers for being too expensive for this compliance. I see a potential as we move ahead that very necessary human connection with the client could be, to use the word that's been used, disruptive. I'm just curious, by throwing it up in the air, how you see the future, which will not be my future, in the psychology of the relationship, and it's a very precious one, between the client and the lawyer.
I would see, and I think it's a fair question, and I think maybe part of the answer comes down to the issues of risk and value, or risk and perceived value, where I think technology and automation, machine learning and things like that, will make some tasks more efficient, but in terms of the relationship, it may eliminate the relationship between the lawyer and the client for lower value matters, where the client is willing to take the risk on those matters without involving the input of somebody who specialises in that area. But when it comes to the higher value issues, or the things where there's more at stake, then even though the answer might be coming from a computer that's using AI and machine learning to read the relevant authorities and those sorts of things. The client will still look to a human being for a long time, I think, to walk them through that process to assure them that this is the right machine to be using and this is the right answer that it's come up with. So I think the relationship will still exist where the value is there, but for some things where the risk and value is perceived to be lower, then there may be a diminishing of the relationship.
And just to pick up on that, I have recently been approached and somebody said, we want to amend this trust deed. And so I was reading the trust deed and someone had clearly, not valued it enough, so they'd gone to Mr. Google, I assume, and typed in trust deed precedent. And what they'd actually gotten and signed as their trust deed was an Australian precedent. So it's littered with these definitions that are just not at all relevant to New Zealand. And in fact, the process to amend the deed itself said you have to get the approval of the Fair Working Commissioner of Australia. And it's so wrong. It couldn't be more wrong. But they thought, clearly whoever had done it had thought that they'd gotten, trust deed precedent, copy, paste, sign, done. And so that's sort of that lower end of the work. And I do see it that the value in the relationship is increasing for the clients who understand the wisdom that is brought from experience. And that's where lawyers can really capitalize, is how can they add value to their client and their experience beyond just the words on the page. Why are you doing this? Where do you want to be in 10 years? Pushing them with those sorts of questions. And that's where I think there's real chance. And the problem is, if we look at the education system, we're taught to memorize cases and come up with ways to defend arguments and things. We're not taught the soft skills of client relationships, apart from a really brief thing in professionals. But that's actually where the real value is. It's actually listening. It's actually reflecting back what your client has told you so that you can come to a solution for them. And that's where I think, certainly for us, that's what we're looking for in new graduates, is the empathy, the personal relationship is really key. Because as we're saying, you can, the books on the shelf are there, you'll be able to find the answer, but how do you convey the answer? How do you communicate with your client is really, really important.
I think another thing too, just to take on from that, is that within OneLaw, the biggest problem we have always when we're bringing a new client on board is all of this shabby information that we have to take from their old systems. And it's really interesting because these old systems obviously are less strict, less tight, less procedural. And so this means that the client or the customer is often really poorly defined, and their relationships are poorly defined, and their touch points are poorly defined. So when you're bringing it into a modern system where we've gone, okay, what is the future customer? The future customer is their social media connect. All these various elements and entities that a future customer is, and you're bringing this data across. And so with a lot of firms, the reason they don't communicate a lot with their customers is they're a bit scared that they might be dead, or they might not exist, or they're just a bit worried. And so therefore, it makes the one-on-one picking up the phone the safest way to relate. And it is, starting with a new firm, say if a firm that's hived off with OneLaw is way better than sort of bringing across, 30 years of Infinity or Lawbase or whatever information into the system, and then having to go through and deduplicate it and all the things you have to do to have trust. And modern systems, I think, are far more trust-driven. So the data has to have integrity, whereas older systems there was less integrity, and therefore just that little bit of fear about talking to your customers as a result.
I think a takeaway that those who are working in the industry should leave with is that if you want to improve efficiency, which you should be doing because that's what every business should be doing, Even though law is a profession, I acknowledge that. If you want to improve efficiency, then use what you have around you that's there and available. We went paperless about 3 years ago, overnight. We went paperless, and all it took was creation of 3 folders in Windows Explorer. You know, you go to File Manager, Windows Explorer, in Windows. 3 folders and a system that was basically a 2-page procedure. And so what that enabled us to do is, you know, a couple of weeks later, once we felt that we were confident that everything was going to be okay, we trashed all of our hard copy files except for the deeds and wills. And that was an incredibly uplifting experience. And that has saved us hundreds of thousands of dollars over that time, because now we operate with no admin staff. And now, because we have used innovation and the technology available to us, what we can then do is scale. So every time now we add new lawyers, or every time we open a branch somewhere, and we're considering opening branches in Auckland at the moment, and goodness knows where. It only costs us for the property. We don't have to employ a slew of extra people to do all of this other stuff. And when they talk about robots replacing lawyers, I really don't believe that. I think robots are going to replace admin staff. I think you will see in future law firms that have no admin staff whatsoever, and technology assisting lawyers to be able to do their jobs with a reduced amount of risk, because there will be less moving parts, and from different places, from home, from overseas, and their clients don't need to be even in the same country anymore. We're seeing that now. I mean, it's happening now. That's where we're moving to. And some firms are getting on board that, and some firms are digging in.
Why do 80% of you still use Word to render your bills? That's always interested me. We have this sophisticated invoicing engine, and then we have to push it to Word so that you can render your bills.
How else do you change the font?
Makes sense. Everyone uses Word, don't they?
Are there any questions that we actually haven't touched on yet? I mean, it doesn't have to be limited to those 2 big questions. I mean, anyone wants to maybe bring up some other topic? Scott?
You talked before about Australia as government sort of forcing changes, or changes with government prompting changes within the law industry, and I've seen that. I'm not sure if it's in place yet, but in regards to e-conveyancing being compulsory in some Australian states, either now or in the near future, do you think New Zealand needs that kind of government intervention to try and pick up the uptake of technology by law firms?
Well, you're looking at me, so I'll start.
You looked at me.
So, yeah. So the change in Australia was one to do with the actual legislation there. There was no directive to implement any technology. There was no technology needed to implement the change. So does New Zealand need to change? I don't know. I think that's probably a question for you guys. Are you happy with the businesses that you're working in? How can they be made better? Is government red tape a hindrance to your business, or is it actually a nice security blanket? You know that, for example, a non-lawyer can't provide legal services. Does it need to be deregulated? I'd say it doesn't need to be.
Well,
I say yes,
think it's more
it
about
does.
the market view. I mean, the better company, whoever serves clients better, will win out of it, and that's the nature of the market. And lawyers aren't different to any other businesses, really.
But the lawyers are a guild. I mean, it's a medieval guild protected by the Lawyers Conveyances Act. And law firms can't have accountants and business managers and diversity on their boards, they could only have lawyers sitting around that table, which, I mean, you mentioned a charity that only has lawyers on their governance body. It would be a really, I mean, you know, I won't pass any comment on that scenario. Lawyers and Conveyancers Act needs to be reformed, like they did in the UK and Australia, 2001. Yeah.
The interesting thing though is because we kind of touched on this a little bit, but partners in law firms have an inherent view, which is what's brought us success in the past will continue to bring us success in the future. So there are definitely, that's part of the issue, is that the new technology, the new innovation, whatever it is, that's not how we've done business in the past. And the mindset shift that actually has to happen is for those key drivers within the law firm, some of whom may be in this room, need to switch their thinking to say, actually, we need to be open to new ways of doing things and open to innovation and open to that what has brought us success in the past probably will not bring us success in the future, because the world of the future will be different. You know, I've got young children, 4 young children. What are they learning in school? What jobs will be open to them compared to when I graduated? You know, it's going to be different. It's just going to be different. So I think for the legal industry itself, there's the inherent checks is that people are in positions of power within law firms, and they won't be there forever. So are they willing to invest in technology change and things that they won't see in their remaining years? So it's kind of this inherent tension, if you like, that we've kind of mentioned, some of us have mentioned it, but just to have said it, that's an issue.
There's also although there's frustration in the legislation surrounding that, to give our government some kudos, it's probably one of the more API-rich governments in the Western world. So API is an application programming interface, so you know, we can talk to the company's office, we can talk to land transfer, we can talk to all sorts of different, and we can build that community where you can go in, for example, bring up a client and you can see all the entity relationships that they have and where the conflicts are. So to give them their dues, it's probably the legislation that's the problem. The government is definitely opening up, and it's becoming very API rich, and that's going to be beneficial for a lot of us, I would say.
I wonder whether ultimately it will be driven as well by demand in the market, so that maybe we've seen that more with a profession like accountancy, where there are obviously there are tools out there. Like once upon a time, I guess MYOB was innovating, and I guess they still are trying to, and then you've got Xero, their innovations, but I think a lot of the accountancy services firms, there are cloud-based tools that their clients are using for things like payroll management and all of these different areas. The clients are aware of these tools that are out there because the tools have risen to the prominence and have the share of the market that they need, and the accounting profession has to go with that and has to start using those tools because their clients expect it. So I guess the question I ponder on in that regard is, what are the tools that our clients are going to demand that lawyers start using? Because I really, there aren't that many. There's no equivalent, I don't think, for lawyers yet of a Xero or even a payroll package or anything like that.
This is because I'm allowed to do my own tax return, not that they want to do it. Whereas I'm not allowed, I'm allowed, but I wouldn't do my own, legal document. So you have to get the legal framework that provides a sort of protection against...
People are definitely trying in terms of things like automated documents and templates that you can access, that you can purchase, do-it-yourself type stuff. I mean, I guess do-it-yourself wills have been out there for a long time with varying degrees of success, but that's another one where there's now an online system that will walk you through the process of creating a will. So there are definitely people out there trying to create those things and trying to build market share in terms of technology that's relevant to legal issues, but I don't see anything that's really sort of taken hold in a really powerful way in any of those areas. I agree with you. I would say it is coming, but it hasn't hit yet.
I mean, the other interesting thing too would be though, that the average hourly rates in the accounting industry have been steadily dropping. So you have to be aware of that commoditisation and profit on an old style model is not workable. So yeah, there's elements of, I guess, the way the accounting industry is disrupting itself or being disrupted that is that has an effect on income.
Because we've cut our teeth on legal aid, we could easily go to the market and charge a quarter of what any other law firm charges. Now, that should send shivers up the spines of any business person who owns a law firm, because having a competitor in the market who can do that could create a price war that would devastate the market. And we're obviously not going to do that. But what it means is that when we charge our private clients the same as you charge your private clients, we make 3 or 4 times more profit than you do. And that's because of efficiency. That's where technology is going to assist law firms, and those law firms that invest in it are going to see the benefits of it, not through making extra profit, but just through surviving. Because, you know, the days of lawyers charging $300, $400, $500 an hour, they are coming to an end. Yeah.
But you just commented before that you haven't employed any new pre-existing, well, you just used pre-existing technology, right? There was no sort of innovation in that way. So do you think, and it's probably a question more to Stephen and Kris, do you think it's more change of thinking from lawyer perspective than actually using technology? Because technology is there, but they just don't use it. Well, not to the degree they should be using
80% of it is changing. I mean, we have invested.
Like, how you decided, okay, well, we just do it, or somebody was pushing you, or how did it happen?
We have invested in technology, but that technology is the basis of us going forward. So there was plenty of stuff on the market that we could have used anyway. I use a lot of Excel to do all of my business analysis and internal things. I use Word to write out policies and procedures.
What about bills?
Bills. Oh no, our practice management software produces the bills, but there's plenty of practice management software like OneLaw and others that can do it as well, and it's actually quite accessible, quite cheap. And aside from the fact that if you've got a huge mess of information that needs to be transferred across, I absolutely agree with that. It should be a fairly painless thing. I would say 80% of this is in the way you approach it from a business perspective, and there's a component of technology there, but there's still a lot of low-hanging fruit, if you like, that you can pick before you have to start spending too much money.
So is it fair to say that a barrier to innovation is in that many lawyers are very bright, really very intelligent people, but they're not really business people? But because they have all the decision-making power in organization, that becomes a barrier, because they're just not really getting it, to put it bluntly, and that becomes a barrier.
Plus they're successful in what
yeah, exactly. Like somebody said, they believe that by doing what they were doing, which was great at the time, and maybe still is, but it will still continue to be great. What I guess I'm trying to ask, quite frankly, is there a need for some sort of more education in terms of general business skills? Maybe some initiative that can be driven by the law society. I don't know. It should be like coming from inside the profession. Because if lawyers as partners are decision makers as they are directors, and they don't have business skills, to me it's really not a great thing. How can that be addressed?
I mean, depending on the firm, there's 2 elements to a firm. There's the legal side and there's the administration side. So depending on the firm, they will have practice managers, or big firms will have CEOs.
Sure.
And they tend to, it would be very unusual for the partnership to argue with the recommendation that comes out of the administrative side of the business.
Okay.
So, and some administrators are quite old school and some are quite progressive, but generally they tend to steer most larger firms more than the lawyers do. So the partnership, very unusual for a partnership to sort of say to their practice manager, we're going to do the opposite to what you're recommending. So, and dangerous for them too, for the lawyers, because practice managers can be quite fierce. And so yeah, you've got, and when you're writing a practice management system, you're writing it for practitioners and administrators. So you're writing a practice system which has really not a lot of relevance to the administrative entities that exist within that, which handle all the money, which most practitioners aren't really interested in, the sort of the financial side of it. So, I mean, practice managers tend to be the power of most mid firms, large firms, etc. Unless you're highly innovative like these guys, and which help, devolve it through. But and the other interesting strength in your industry, which I don't know that you realise, is you're collegial. Now, if somebody in my industry was to say they could do things for a third of what I would do it, they would do it, and they would just slam everybody, and they would bring, you could not get a group of IT people in a room like this. There's no way you would get any agreement, and none of them would ever listen to you anyway, because they all know it all. So your industry is collegial, so you do tend to work together, and there is a strength. And accountants less so, but of the professional services, the legal industry tends to be very collegial, and there's a lot of strength in that, which I think you don't always make the most of.
I think one of the aspects that reinforces that concept over time is the notion of conflicts. You can't act for everybody, and the notion of personal relationships and trust, which, as the questioner asked earlier, how's that going to erode over time? My take on it, and I think I'll touch on a couple of other points in answering, is, and I'll relate it back to your chatbot. The number one problem in all the surveys when people talk about IP is it's too complex and too expensive. Sorry, they're the number 1 and 2 problems. It's no more complex than any other aspect of law, I'm sure, and it may or may not be more expensive depending on the nature of the problem. But access to information is obviously then critical to addressing the complexity for those that are capable of dealing with it themselves. And so a chatbot or a sophisticated way of focusing a person with a query down on an answer in a time-efficient manner so that I'm not on the phone to people or meeting with people answering the same questions every day of the week means that then I can go back to the office, and rather than charge my client X dollars, I can actually charge them less and spend more time charging rather than chew up half my day answering the same questions. So touching on, coming back to erosion of hourly billing rates over time, that isn't I'm not sure about the accounting industry, I don't know anything about it frankly, but I would say that it's not necessarily a bad endpoint. If times number of hours worked, overall profitability can increase or at least stay the same. So I think there's some positives in there, some synergies in there, and that's why I think the chatbot is a fantastic solution to a particular set of prospective clients.
I think it's important to say, one other thing is that most of us who became lawyers actually did it because we wanted to help people. I know that sounds shocking, but that's usually the motivation of why we studied law in the first place. So all these other things it can get difficult to work out what's the best thing to do, but fundamentally, I think for Kris and I'm sure, we actually want to help people with their legal problems and help them achieve a solution that helps their lives improve, It's kind of a baseline.
Sure. I'm mindful of the time, it's actually past 5 already, just noticed. So let's have maybe 1 or 2 more questions, and then maybe we'll just sort of close it, the formal part. If you have any questions, you can maybe talk with the panel one-on-one. Hope they will be able to spend a few more minutes with you, but I wouldn't want it to be like mandatory. So any final questions from anyone?
This is the point where everybody sits and hopes that nobody asks.
Andrei, can I just say one thing?
Yes,
which is, some people may know, but I'm doing a podcast called Seeds, and I'm interviewing people, and I'm actually recording this session, so I'm planning to put it up as a podcast episode. So if people are interested, they'll be able to come back and listen. And I'm also, so this is really using technology, isn't it? I'm videoing this session as well. So my plan is to make it available for people so that people who aren't in the room who are interested can actually access it. So if people are interested, come and see me. The podcast is called Seeds, and there's 104 interviews now with Christchurch-based people who are doing inspiring things. So that's my little plug.
Yeah, actually, no, it's a great point. So can I have your permission, because we have access to email addresses, right? Because you're registered. Can I have your permission to send you links to Steven's podcast and recording? Okay, great. Cool. All right, anyway, look, I'd like to thank, first of all, our panel, and certainly I'd like to thank all of you for coming here today. I think, well, for me personally, it was very, very enlightening and insightful, and I personally have learned a lot, and I hope everyone has learned something. And yeah, thanks very much. It's been great, and if you still have a few minutes, please stay around and again maybe meet new people, make new friends, or just ask them all questions one-on-one on the panels. Anyway, thanks very much.